So friends, here we are again, having to talk about Donald Trump's dirty DOJ officials. This time, the United States Attorney for the District of Columbia, Jeanine Pirro, who just got caught trying to engage in some prosecutorial overreach. She tried to convince a grand jury in Washington, D.C. to indict two people in two separate cases of felony charges. And the grand jurors, sitting as the conscience of the community, told Jeanine Pirro, no, we will not indict these two people on felony charges. Points of light, friends. Points of light. So friends, I'm not going to lie. I love this story because it involves regular folk, grand jurors, citizens who come from all over the D.C. community who are called upon to decide if one of their own should be criminally charged. The grand jury, sitting as the conscience of the community, gets to make that decision. And in the process, the grand jury also serves as a safeguard against prosecutorial overreach, abuse, and misconduct. And friends, multiple grand juries in Washington, D.C. just told Jeanine Pirro to stand down. We will not indict these people for felony crimes the way you are telling us to do. Friends, let's start with the new reporting. This from NBC News. Grand jury declines to indict man who threw a sandwich at federal officer in D.C. And that article begins, you could get a grand jury to indict a ham sandwich, the saying goes, but in Washington, a federal grand jury just declined to indict a man for throwing a salami sub. The grand jury did not return an indictment against a former Justice Department employee who was seen on camera throwing a hoagie at the chest of one of the federal officers President Donald Trump has deployed in the nation's capital, according to two people familiar with the matter. The grand jury's decision not to indict Sean Dunn is another sign of pushback from Washington, D.C. residents over Trump's deployment of the National Guard and other federal law enforcement agencies in the city who have put a particular focus on immigration enforcement. The New York Times was the first to report the news. The incident took place on August 10th at the corner of 14th and U Streets, Northwest, in the heart of the U Street corridor, a neighborhood that played a historic role in the civil rights era and is now a nightlife hotspot. And this quote from the gentleman who ended up throwing the sandwich, quote, F you effing fascists, why are you here? I don't want you in my city, Dunn, age 37, yelled at officers in the video. After apparently throwing the hoagie in front of a subway location, Dunn ran. Officers chased him, and he was arrested on the scene and later processed and released. Dunn was then charged in federal court with felony assault on law enforcement, and the White House posted a highly stylized social media video of his arrest on those charges. He was then once again ordered released. It's not the first time federal prosecutors have had trouble getting a Washington-based grand jury to indict a resident who opposed the new law enforcement presence in D.C. Federal prosecutors failed to obtain an indictment of a woman who was arrested for allegedly assaulting an FBI special agent at an immigration-related protest, the Times reported. And friends, before we turn to the ins and outs of how a grand jury works, I spent decades presenting cases to grand juries in Washington, D.C. Let's turn to the reporting about the other case in which a grand jury refused to indict someone on felony charges, as U.S. Attorney Pirro insisted they do. This from CNN. Piro's office fails 3 times to win felony indictment of alleged attacker of FBI. And that article begins, the U.S. Attorney's Office in Washington, D.C., that's run by Donald Trump appointee Jeanine Pirro, has struggled to secure a grand jury's approval of at least one indictment in federal court this month in an indication of possible issues arising with the office's crackdown on crime. In one case this month, related to an FBI agent and an immigration officer allegedly scraping with a detainee, the federal grand jury in Washington voted no 3 times. The court record doesn't say why the grand jury refused to approve the felony assault charge against D.C. resident Sidney Laurie Reed each time it was presented over the last month after she was arrested in late July for assaulting or impeding federal officers. Grand jury indictments are infamously easy to secure, and it is exceedingly rare for a grand jury to refuse to approve an indictment prosecutors present. And friends, here's a quote from U.S. Attorney Jeanine Pirro that shows just how out of touch she is with law enforcement and the prosecutorial practice in Washington, D.C. Quote, sometimes a jury will buy it and sometimes they won't. So be it, Pirro added. That's the way the process works. Friends, that quote shows a staggering lack of understanding and reflection and circumspection by former Fox News host Jeanine Pirro. So let's take a few minutes talking about the ins and outs of grand jury practice, specifically in the courts of Washington, D.C. I indicted more cases before grand juries in D.C. than I could ever count, that I could ever remember. But here is how it works. The chief judge sends out grand jury notices that require citizens from all over the District of Columbia to come and appear for grand jury service. Now, the nuts and bolts of grand jury practice, a grand jury consists of at least 23 people, but in order to do business before a grand jury, present witnesses, make arguments, seek indictments, you need a quorum, 16 grand jurors. So 16 of the 23 who are assigned to a particular grand jury, and we have multiple grand juries up and running simultaneously all the time in D.C., at least 16 of the people must show up each and every day for grand jury service in order for the grand jury to have a quorum such that we prosecutors can begin presenting evidence and witnesses and seeking indictments. So once you have 16 people, you present the evidence supporting your assertion that a crime has been committed and you have adequately identified the person that committed that crime, and you have enough evidence to satisfy the probable cause standard in order to ask the grand jury to return an indictment, a felony indictment against that person. Now, mind you, felony crimes, felony charges have to be issued by the grand jury. Prosecutors can't issue felony charges, felony indictments on their own. We can issue lower level charges, misdemeanor charges, by simply signing a document. It's called a complaint, saying, I, as the prosecutor, hereby certify that the defendant committed the following misdemeanor crime on the following date within the District of Columbia, and the person is charged with a misdemeanor. You can do it by complaint, but a felony charge has to be run through the grand jury, and the grand jurors have to vote in favor of indicting somebody for a felony crime. When that vote is taken, remember I said you have to have 16 grand jurors present to have a quorum to do business? 12 of the 16 have to vote in favor of an indictment in order for a true bill, an indictment to be returned for a felony crime. If 11 or fewer people vote in favor of charging someone, it's called a no bill. They have rejected the prosecutor's request to return a felony indictment. You all have heard the standard observation about how easy it is for prosecutors to win an indictment in the grand jury. A grand jury will indict a ham sandwich. Well, apparently this grand jury wouldn't indict a Subway sandwich, more precisely somebody who threw a Subway sandwich at an officer. Is it a crime to throw a Subway sandwich at an officer if that sandwich makes contact with his body? Yes. Is it a felony? I'm not only going to say no, but I'm going to say hell no. That is not intending any disrespect to law enforcement. Don't throw sandwiches at police officers. Regardless of how upset you are that Donald Trump has sent an invading military force into the District of Columbia, regardless of how upset you are that Donald Trump is an aspiring dictator, a wannabe fascist who's doing things to the citizens of D.C. that he has no right, no lawful authority to do, don't let that inspire you to throw anything at an officer, a sandwich or anything else, or assault an officer, make bodily contact with an officer. That's a kind of assault. We call it a battery. An unconsented touching is a battery, which is a form of assault. Don't do it. Oh, but get out there and protest and march and rally and yell and exercise your First Amendment rights, but don't assault officers or anybody else. I know I'm preaching to the converted, friends, but bear with me. Once I get going in my kind of prosecutorial zeal, I can't stop. So the first thing I did when I saw the Subway sandwich story reported out a couple of weeks ago now, I called two of my former closest colleagues, and together we probably have about 110, 115 years of prosecutorial experience in Washington, D.C. And I said, gentlemen, can you just check my prosecutorial instincts? This is a misdemeanor all day long. No, there's no possible felony charge that could be brought based on somebody throwing a sandwich at an officer. And we were all in agreement. I'm not, pushing off the responsibility for that decision on them. This was mine, but I wanted to check my own instinct. And it was unanimous. This is a misdemeanor offense, throwing a sandwich at an officer. No injury, no harm. So, of course, Jeanine Pirro engaged in overreach by demanding that the grand jury return felony charges. We got to put this guy away for 8 years, which is the maximum punishment for assaulting a federal officer, even with a sandwich. And the grand jury flat out rejected Jeanine Pirro's demand that they indict felony charges for the Subway sandwich wielding person, who, by the way, was a paralegal at the Department of Justice, who was so incensed by what Donald Trump is doing to the citizens of the District of Columbia, doing to all people in D.C., that it looks like he lost his cool momentarily and tossed the sandwich at a police officer. But the grand jury would not go with Jeanine Pirro, would not indict the felony charge, so it looks like Jeanine Pirro will direct her prosecutors to sign that complaint, misdemeanor, and try to bring that charge and go to trial and hold this young man accountable for throwing that sandwich at the police officer. But it gets worse. There was another person, a woman, who got in between like an ICE officer and an FBI agent and somebody they were trying to detain for immigration purposes. And there was pushing, there was a scuffle, and that woman was charged with felony assault on a police officer. And Jeanine Pirro had her prosecutors present that case to the grand jury and seek a felony indictment, not a misdemeanor. Again, this is misdemeanor territory. And the grand jury said, no, we, sitting as the conscience of the community, believe the evidence does not support a felony charge. And they rejected that felony charge for that D.C. resident. Sydney Lori Reed is her name. But friends, now comes the prosecutorial abuse, because after a first grand jury rejected the felony indictment, Pirro had her prosecutors go back into the grand jury and try again. And a second grand jury, or a second vote in the same grand jury, it's a little unclear whether this was the same grand jury or successive grand juries. Second time around, the grand jury said, no, this doesn't warrant a felony charge. And then Pirro made her prosecutors go back in a third time. And for the third time, a grand jury, sitting as the conscience of the community, guarding against prosecutorial overreach, abuse, and misconduct, said no. So it looks like that person will also be charged with a misdemeanor assault, a far lower level criminal offense with far less punishment than the 8 years in prison as a potential maximum punishment for the felony assault on an officer. Friends, this is a just blindingly bright beacon of light. Why? It is citizens who take an oath to honestly and ethically and fairly evaluate evidence presented to them by a prosecutor and see if that evidence supports a felony indictment against one of their own, somebody in the District of Columbia. And a total of 4 votes, the grand jurors said no, 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 no. They refused to kowtow to Jeanine Pirro's overreach and abuse. This is another form of the citizens being one of the few checks left against governmental abuse being perpetrated against we the people by Donald Trump and his corrupt cabal. And, you know, if Congress won't do it, they won't serve as a check and balance against a criminal, abusive, corrupt executive branch. If the Supreme Court, the 6-justice right-wing majority of the Supreme Court won't do it, well, then we the people will do it. And we the people take lots of forms. We the people take the form of marching and rallying and protesting. We the people take the form of contacting our elected officials and demanding accountability for a corrupt president. We the people take the form of nonprofit organizations going into court every day and kicking the butts of Donald Trump's cruddy DOJ lawyers who are trying to support Donald Trump's lawlessness and unconstitutionality in his executive orders. And those nonprofits are winning in enormous numbers, 75, 80% of the cases. And we, the people, take the form of grand jurors sitting as the conscience of the community, standing up against an out-of-control, abusive, corrupt, and indeed criminal executive branch, a presidential administration, and saying that we will abide by our oath, we will evaluate the evidence presented to us, and the evidence doesn't support what you're trying to make us do. Bring felony charges against people who, by and large, are protesting, are expressing their outrage at the coming fascism of Donald Trump. Doesn't mean that we are supporting assaulting police officers. Hell no, don't do it. But the citizens are standing up and speaking out and staying strong and serving as a check, as a balance against one branch of government when the other branch of government, the legislative branch, won't do it, and the third branch of government, you know, atop of which sits 6 compromised Supreme Court justices, won't do it. We'll do it. We'll do it, both in and out of the grand jury. We'll do it.